All right, let's go ahead and get into this. So Judicial Watch actually gets to tell their story about what happened behind their open records request, why they won the lawsuit, and what Fani was trying to do behind the scenes. But before we get into that, I want to give a shout out to Steve Sadow. He actually was the one who was able to produce the document over on X, basically showing everything that Judge McBurney said when deciding what was going on in this lawsuit. He says the Fulton County DA Willis found liable for costs to the Georgia Open Records Act violations, including misrepresenting the non-existence of documents, despite having previously informed Judicial Watch 4 separate times that her team had carefully searched but found no responsive records. Now they suddenly were responsive records.
Stop the cap.
Yeah, and as y'all know, or may not know, this was actually Gunna's lawyer. So Steve Sadow represented Gunna in the entire YSL case as well. Of course, we've got the Honorable Doug Weinstein responding as well, aka Uncle Doug. He says, DA Willis's actions continue to do a disservice to the fine prosecutors in her office as well as the taxpayers in Fulton County. Amen to that, Doug. I'm sick of paying for it. We deserve transparency and honesty in our elected officials. Let's see what Judicial Watch had to say about this whole lawsuit. A court finds Fani Willis in default in open records lawsuit, order her to produce records in 5 business days. I highly doubt that's going to happen. Judicial Watch announced today that the Superior Court in Fulton County entered an order granting a motion for default judgment against District Attorney Fani Willis in Judicial Watch's lawsuit for communications Willis had with Special Counsel Jack Smith and the House January 6 committee. In doing so, the court grants Judicial Watch requests for the attorney fees and orders Fani Willis to search for and provide releasable records to Judicial Watch within 5 business days. The March 2024 lawsuit filed with the Superior Court of Fulton County, Georgia, after Willis and the county denied having any records responsive to an August 2023 Georgia Open Records request, or Act request, for communications with Special Counsel's office and the January 6 committee. In this lawsuit, Judicial Watch stated that Fani Willis's representation about not having records responsive to the request is likely false.
Stop the cap.
Shocker. Judicial Watch referred to a December 5th, 2023 letter from the House Judiciary Committee Chairman Jim Jordan to Willis that cites a December 2021 letter from Fani Willis to the then White House, or to the then House January 6th Committee Chairman Bernie Thompson. In a letter, Willis requested assistance from the committee and offered to travel to D.C. I wonder why that is. In May of 2024, Judicial Watch asked the court to declare a default judgment, noting that Willis was served with the lawsuit in March of 2024 and had not filed an answer, which was due 30 days after service. Wow. So that was 60 days later. They recently issued default judgment statements. The court finds defendant Willis in her official capacity is in default and has been since April of 2024, April 11. Further, Willis never moved to open default to any basis, not even during the period when she could have opened default as a matter of right. She never paid costs and she never offered up a defense. Plaintiff is thus entitled to judgment by default as if every item and paragraph of the complaint were supported by proper and sufficient evidence. And then they cite the OCGA 91155A. Here, the plaintiff has established the defendant violated the ORA by failing to either turn over responsive records or else notify the plaintiff of her decision to withhold some of such records. So she basically didn't say anything. She just kept moving. Like, yeah, I'm trying to get this RICO done, so y'all can figure it out. In his complaint, the plaintiff sought the following relief: a declaration that the defendant has violated the ORA, in order for the defendant to search for all records responsive to the plaintiff's request without further delay, an injunction ordering the defendant to cease withholding non-exempt public records responsive to the request, an award of attorney's fees and costs pursuant to OCGA 50-1873, which we now know that they were granted. A writ of mandamus ordering the defendant to provide the requested records and any other relief the court deems proper. So now that we know that, we can fast forward a little bit and see what Judge McBurney had to say about everything that Fani Willis was doing. This is only 5 pages long, so it should be pretty quick, but it's interesting to see how out of the way Fani Willis went to avoid just simply doing her job. So it makes you wonder what she's hiding. And I also want to know why Judicial Watch wanted to get these in the first place. We'll get into that here in just a second. This is an order granting attorneys fees and costs. The plaintiff submitted an Open Records Act, will be referred to as an ORA, request to the defendant on August 22nd, 2023 by way of the Fulton County's ORA online portal. That same day, the plaintiff received confirmation that its request had been delivered and would be channeled to the appropriate department. More delays, right? More tactics to delay. The following day, the county's open records custodian sent the plaintiff an email confirming that the district attorney's office had received the inquiry and asked the plaintiff to simplify its ORA request. Basically saying, you're asking for too much here. Can you tell us exactly what you're looking for? They said, sure. Literally 5 minutes later, before any simplification had occurred, the plaintiff received a second email from the records custodian. After carefully reviewing your request, we do not have the responsive records. This is where it gets messed up. Can't be lying. Or maybe you can if you're Fani Willis, I guess. This response was perplexing and eventually suspicious to the plaintiff because given the plaintiff subsequently uncovered through own effort at least one document that should have been in the district attorney's office possession that was patently responsive to the request. They said, y'all lying. We've got the piece of paper right here. What are you saying you don't have it? This would be included. You have to have something. Don't tell me there's nothing there because I've got a piece of the puzzle. I just need the rest of the puzzle. This discovery prompted the current litigation filed on March 2024, seeking an order directing the defendant to comply with the ORA and provide all responsive records. During the pendency of litigation, the defendant thrice more denied the existence of any responsive records. Once in a request for admission and twice via answers to interrogatories. Every time. We have searched and there is nothing. Defendant ultimately defaulted and the court entered an order on December 2nd, 2024, directing the defendant, Fani Willis, to conduct a diligent search for her records for responsive material and to provide any responsive records that were not legally exempt from disclosure. The tough part about that is guess who gets to decide if the responsive records are not legally exempt from disclosure? Fani Willis. So that's the problem there. And then what happens is they're like, oh, okay, here you go. And they've got, where's my piece of paper? They've got this one piece of paper. They're like, oh, here you go. Here's our responsive records. And Judicial Watch says, whoa, there should be more than this. Oh, yeah, those other 11 pieces of papers, we left those out. Because those are legally exempt from disclosure. Sorry. And then you start another back and forth there. If the defendant elected to withhold all or part of any responsive records, she was further directed to comply with OCGA 50-1871D by identifying the basis for withholding, which we just talked about, right? Defendant's compliance with the court on 2nd of December order consisted of an undated, unsigned 2-page memo to the plaintiff from the defendant's open records department. In this memo, the defendant announced that there still were no records responsive to one set of the plaintiff's requests. She still did nothing. But that there were, in fact, records responsive to the plaintiff's second set of requests, communications with the United States House January 6th committee, but those were exempt from disclosure. She decided, nah, we ain't giving you those. Oh yeah, we found it. Actually, they were in the closet over there. We found him, but you can't have him. Defendant, despite their reservations, did gamely attach to her memo a copy of the letter she wrote to the chairman of the House committee that, one, does appear to be covered by any of the exemptions identified in that memo, and two, had already been identified by the plaintiff as a responsive record that was wrongly withheld. She messed up. They had a piece of the puzzle. She said, there's no puzzle. This lady, man, if something as simple as this, Fani Willis can't get right, imagine what else is going on. Somehow, something had changed. Despite having previously informed plaintiff 4 separate times that her team had carefully searched but found no responsive record, now there suddenly were, but they were not subject to disclosure under the ORA. Plaintiff's deposition of the defendant's records custodian shed some light on this mystery. He admitted that there was no search for the records back in August of 2023. No. Go away. He further clarified when the plaintiff did not go away, but instead sued, there still was no organized, comprehensive examination of the district attorney's office records that would await the court's December 2nd, 2024 order. Again, we talk about Fani Willis and the DA's office getting away with acting like they're the law and that they don't have to abide by the law. They are the law. I mean, it is what it is. They absolutely are. And as we see here, there's so many ways they can delay, withhold. It's just take my word for it, guys. There's no record. There's nothing there. And it took Judicial Watch having a piece of the puzzle to say, hey, we know there's something there and you guys are withholding it. And then Fani Willis's office says, oh, okay, well, maybe we'll look again. And then we have the custodian saying, well, actually, there wasn't really a search. I just asked and they said, you're not getting it. Stop asking about this. The ORA is not hortatory. It is mandatory. Non-compliance has consequences. One of them can be liability for the requesting party's attorney fees and cost of litigation. They should not have to fight this hard to get the DA's office to comply to an ORA request. To recover its relevant and reasonable fees and costs under the ORA, the plaintiff must do 2 things. First, it must show the defendant violated the ORA. Pretty easy to see. Second, the plaintiff must also demonstrate that the defendant lacks substantial justification for the violations. Fani Willis just does what she does. That's the justification. Here, the plaintiff has done both. Most basically, by operation of the law, defendant acknowledged violating the ORA when she defaulted. By actual evidence, proves the same. Per her records custodian's own admission, the district attorney's office flatly ignored the plaintiff's original OR request, conducting no search and simply and falsely informing the county's open records custodian that no responsive records existed. If you did not have the resources to fight this in the first place, you would just have to shrug your shoulders and say, well, I guess Fani wins this one. And the reason she had to pay $21,000 worth of legal fees is because that's what, and it's probably more than that, the Judicial Watch had to put up to actually fight this and get what they were asking for. So imagine if it were you or me, a regular citizen who has rights under the ORA to request this, and they say, there's nothing there. Sorry, guys. You're not going to talk about it on your little YouTube channel. And if you have a problem with it, you can fight it and try and figure it out yourself. But we're not going to give it to you willingly. We know now that is simply incorrect. Once pressed by the court order, defendant managed to identify responsive records, but has categorized them as exempt. Even if the records prove being just that, exempt from disclosure for sound public policy reasons, this late revelation is a patent violation of the ORA. Also to note, and even after litigation began, the defendant's records custodian initially merely asked certain employees if they thought they had any responsive records. There was no rigorous review of emails or case files. Wow. And for none of this is there any justification, substantial or otherwise. No one searched until prodded by civil litigation. This is not how the law should work. Given this, the court finds that relevant and reasonable attorney's fees and costs of litigation are properly awardable to the plaintiff pursuant to OCGA 501873B. The evidence from the court's December 2024 hearing on the attorney's fees shows the plaintiff's counsel's billing rate is reasonable and that the items for which are billed are, for the most part, relevant to defendant's ORA violation. From the records made at the December 20th, 2024 hearing, the court finds that the plaintiff incurred $19,360 in attorney's fees. Y'all got that money just laying around that you can use to make sure that Fani Willis does her job? Related litigation expenses are $2,218. Defendant is thus liable to the plaintiff for $21,578. That amount shall be paid within 2 weeks of entry in this order. So ordered this the third day of January 2025, Judge Robert McBurney. This is a mess, y'all. And it's really sad to see because we like to think in the justice system and here on this channel that you're innocent until proven guilty, right? But when you're going up against the system, when you're in a YSL trial and you're fighting this RICO that was built, as we've seen, based on the jury's decision, on a false narrative that was built on evidence that.
Right. And so what we have ultimately is that there is no evidence, none.
Wasn't even there. When you see all the trouble and all the fight you have to put in and go through just to get something as simple as an open records request, it cost you $21,000 for the truth. And that's all because one person, one lady, one district attorney doesn't want to do her job. She doesn't want to do the right thing. She doesn't want to be transparent. She doesn't want to give those rights to the people that so many have fought and died for. It's that simple. Fani Willis's world, and we got to continue to make a change. Let me know what y'all think about this. Is this going to be the last time we see something like this from Fani Willis? And do you think Judicial Watch is done? Because I feel like they're still going to want to push to make sure they get the information they're requesting. We'll have to wait and see what happens there.